Welcome to the From Lab to Patient, Garage to Market podcast with your host, Phil Crowley. In each episode, we will discuss professionals serving the tech startup market and the various issues of importance to those companies. You can find this show on all the major platforms, including YouTube, LinkedIn, Facebook, Apple Podcasts, Spotify, and on our website, CrowleyLawLLC.com. Now here's the host of From Lab to Patient, Garage to Market, Phil Crowley.
Hello and welcome. Thanks for tuning into our podcast. We look to bring you leaders in the life sciences and technology who can share their perspectives on developments in this space, how to succeed, mistakes to avoid, techniques to use to try to accelerate your success, and hopefully help you develop products and services that enrich the lives of thousands or even millions of people. Today, I'm delighted to have as my guest Joshua Goldberg, who's the co-managing partner of Nath Goldberg and Meyer in Alexandria, Virginia, a very experienced intellectual property law colleague of ours. Now, stay tuned because at the end of our discussion, I'm going to ask Josh to give us a couple of tips that you may be able to use in order to accelerate your growth. Josh, welcome.
Thank you, Phil. Happy to be here.
Well, please tell us a little bit about your background and the pathway that led you to your current line of work.
Oh, happy to. So, like many IP attorneys, I have a science background. I have a chemical engineering degree. And between getting that and going to law school, I worked in industry for a couple of years doing drug composition work, making tablets, capsules, pellets, coatings, things like that. I learned a tremendous amount doing that, including that I'm not on this earth to be a bench chemist. So thinking at what I can do instead with my background, I remembered a professor I had who talked about his patent lawyer buddy who had his fancy ranch in Colorado with his 10 sports cars and his helicopter that he would take there. I'm thinking to myself, hey, that doesn't sound so bad. I can do these things. So I went to law school to become a patent attorney. Now, I don't have a ranch in Colorado. My fancy car is a Civic hybrid. And if I had a helicopter, I'd be too scared to get into it. But it still worked out okay.
Well, that's great. That's quite an example of some career development. What are some of the examples of work that you're doing today to help companies thrive and succeed? What issues have come to the fore in terms of intellectual property law that you deal with?
Oh, well, it's a wide variety, Phil. What most often happens is someone will come to me with some sort of great idea, very excited, very enthusiastic. And they say, I want a patent on this so, I could launch a product and have it to myself. And I always have to tell them to slow down a little bit, right? I always recommend starting with a search to make sure it truly is an idea that is patentable. I just went through this yesterday. I was talking with a solo inventor who gave me his idea, was really excited to start it. And after doing a search, I had to tell him, look, I think your chances of getting a patent here are about that big. Was he happy to hear that? Of course not. Was he thankful that he knew now before spending years and thousands of dollars on the process? Absolutely. And I was able to give him some other advice into things he could do that would protect him, assuming he was able to get his business running. Now, I don't want to give it away because one of those is my tips for later. But there are things that can be done even if you can't get a patent.
Very interesting. What are the hot areas in patent law these days? I mean, we hear so much about the impact of artificial intelligence on our businesses. We also hear about the tremendous advances that are happening in biotechnology. Can you give us some examples of things that are sort of at the leading edge that our viewers should know about to keep track of?
Absolutely. And you hit on two of the big ones right there. Biotechnology is one, incredibly hot, and AI. Everybody is interested in AI, both in terms of how can I use AI to make everything I'm doing quicker, easier, better? How can I use AI to have new inventions involving AI? And quite frankly, how can I use AI as an inventor to help me invent? I get a lot of issues like this coming to me. The problem is a lot of people who say, I'm using AI, I have AI, my invention is AI, don't really have much behind it. As an example, I had an inventor who came to me and said, here, I have a wonderful invention. I added AI to this toaster oven. Okay. What does the AI do with the toaster oven? Well, I don't know yet. Okay. How does the AI operate with the toaster oven? What's your algorithm you use? What's the LLM? Well, I don't know that yet either. Well, you don't really have an invention at this point. You have an idea.
Mhm.
And I'm seeing a lot of that. Everybody hears AI this, AI that, and they think just adding AI to something is an invention. You can't just add AI. You need to do something more. You actually need to think it through and build and develop whatever it is you're doing. A couple of other areas that are really important to me with my chemistry background, I do a lot of agriculture work and a lot of battery storage technology work, particularly for energy developed from solar panels and wind farms, wind turbines. These are really hot areas right now.
So, what sort of misconceptions do people tend to have about patent law? I mean, when people come to me uh, just before I send them over to you, Josh, they seem to have the feeling that, well, if I can just get a patent on this, this will guarantee my ability to make my product and sell my product worldwide.
Yeah, you've really hit it on the head, Phil, but I'll narrow it down a little bit. The very single biggest misconception I have to, you know, educate people about, just because they don't know yet, they think they get a patent. It entitles them to do something, to do whatever it is they patented. And I have to tell them that's not the way patents work. What a patent does is it helps you stop others from doing whatever it is that you've patented. So that way, assuming you sell a product that is in the scope of your patent, you can try to keep the market to yourself by preventing others from competing with you. It's a legal monopoly. Everyone I talk to thinks, oh, I have a patent, I can do this. And that's just not how patents work and not what patents do.
So, in other words, you could have a patent and yet not be able to market your particular innovation. I mean, a simple-minded example that I always think of is suppose that you have a patent on bicycle wheels,
Mm-hmm.
and you say, well, look, I can sell these bicycle wheels, and I have a patent on some special bicycle spokes.
Mm-hmm.
And so sometimes people think that if you have a patent on bicycle spokes, you can sell bicycle wheels with your special spokes. And that's not true because you have the patent on bicycle wheels. By the same token, if you have a patent on bicycle wheels, you say, well, I have a patent on bicycle wheels. I can sell any kind of bicycle wheels, but you can't sell a bicycle wheel with the special spokes because I can prevent you from doing that. And what you have focused on, Josh, is that a patent is really a negative right. It
Correct.
allows you to prevent somebody else from infringing on your rights under the patent. And this comes up all the time in the life sciences where you have kind of controlling patents that prevent someone from coming out with an improvement.
Yes, absolutely. And I love your example with the bicycle. By the way, I commonly use an example of a pen. I hope you
Mhm.
don't mind if I use your bicycle wheel example sometimes because it's great.
Please go ahead.
Oh, thank you. But no, you're absolutely right. And the way I always put it to people is because it is a negative right, and I'll use your example, I may have the patent on the wheel, So I can stop you from selling a wheel with your spoke, but you have the patent on the spoke, so I can't sell my wheel with your spoke in it. And that to me is the perfect cross license situation. Say, okay, here, I'll let you practice under my patent. You let me practice under your patent. Let's all make some money together and be happy. Comes up
Right. That
all,
that is certainly the ideal case.
of
We've
course.
had discussions otherwise, and we're talking about one patent now. But a point that you have raised in the past, Josh, has been this idea. Well, it, the focus is not necessarily on just getting one patent, but on sort of getting a library or a portfolio of patents. Can you explain to our listeners why it's important to think about that?
Oh, absolutely. And there are really two main reasons I think that's important. Number one, if you're a non practicing entity or someone who has no capacity to manufacture, say an individual, a university, and this is where it comes up with universities a lot. How do you make money? By licensing out your technology, by selling off your patents. Is it easy to do that if all you have is one patent? Or is it easier if you have a bundle of rights that you could package together, have more interest from people who might want to buy, and also generate more money from the sale or the license? Door number two is always the way to go. Now, the second point I would raise is if you are a company and you are looking to manufacture product and sell product, just because yours works, maybe your patent covers this much property. And if somebody goes and operates over here, they can have a very similar product to you and they avoid your patent. So the idea is you get a patent here and here and here and here and here to try to wrap up anything anybody can do to compete with you and keep competition away. Now, like you said, I'm a pharma guy. That's how I cut my teeth. That's what I
Yeah.
did for the very beginning years of my career. This is incredibly common in the pharma industry. In fact, people who are listening, you might have heard Congress talk about this and the FTC talk about this, how this is per se anti-competitive. Well, sometimes it is if the invention is not really a true invention, but more often than not, there really is a lot of research and development that has to go into that little incremental change to make something better, to make something different, to make something
Mhm.
new, and to keep away anybody else who might compete with you.
Now, people tend to think of, when they think of intellectual property, they tend to focus on patents because I suppose that is the heavyweight of intellectual property protection since it gives you a monopoly in that particular area. But what about trade secrets? How do they fit into the overall thinking that a company should engage in terms of looking at its intellectual property library or portfolio?
Well, I'm glad you asked that, Phil, because trade secrets is kind of the underrepresented part of intellectual property. And I can think of two really main reasons for that. Number one, you don't get a fancy ribbon like you do for a patent with a trade
Yeah.
secret, because the whole point is it's a secret. You don't want to disclose what it is. And number two, the trade secret has to be something that you can reasonably keep secret if you put the effort into it. If it's something that can be reverse engineered, once it's reverse engineered, the secret's out, your trade secret is gone, you have nothing left. Okay?
Mhm.
Those are the downsides. The upside is if you get a patent, the patent lasts for 20 years from when you file it, maybe 21, depending on your strategy. So it's a shortened time period for that monopoly. As a government, the US does not like monopolies. So to give you this legal monopoly, they give you that short time period, and you have to teach others how to make and use whatever it is you invented. For a trade secret, as long as you can keep it secret, it's effective. It can potentially last forever. And the example I always use, which I don't know how much longer I'm going to be able to use, is the formula for Coca-Cola, the world's most popular, most common, most valuable trade secret. I've heard stories that somewhere, and I don't know where, that's part of the secret,
Mhm.
there's an old yellow taped together piece of paper that has the formula for Coca-Cola on it that about 3 people in the world have access to. For whatever reason, nobody has ever been able to recreate it. You can't put it in a gas chromatograph, you can't centrifuge it, nothing like that. Now, when I say I don't know how much longer, this goes back to something we were talking about a few minutes ago.
Mhm.
I've talked with some people recently who are betting that AI will be able to figure out what the formula for Coca-Cola is. If it happens, I think we'll see a lot of Coca-Cola knockoffs out there.
Very, very interesting. Well, before we get on to our further discussion of intellectual property, Josh, I just wanted to take a minute to acquaint our listeners with Crowley Law. We are a boutique law firm of 4 very experienced lawyers who are passionate about helping life sciences and other technology entrepreneurs avoid being taken advantage of as they pursue their dreams. As a former research physicist, I did my work in superconductivity. I have a soft spot in my heart for innovators because I know how difficult it is to create new knowledge. And then as a corporate lawyer, I know how difficult it is to take those ideas, even great ideas, into the marketplace. And so we are focused on helping those people move forward with products and services that can enrich the lives of thousands or even millions of people. We have a website with a wealth of free resources at crowleylawllc.com, where you can see other instances of our video podcasts. We also have some white papers, and just recently, in June of 2025, we published our book, Avoid Startup Failure. Learn the top 10 causes of failure for technology startups and how to turn them to your advantage. So I recommend that you take a look at that and our other resources. And just remember that we're here to help. Josh, let me return to our journey through intellectual property.
Before
There
you
are,
do that, Phil, let me interrupt you and put in a plug for you. I've read your book. I think it's great. I think anybody who's considering to start up a technology based company should read your book and really learn the lessons you talk about.
well, Josh, thank you very much. I really appreciate that. But now back to your discussion of intellectual property. Where do trademarks fit into this kind of library of rights that innovators can use to protect their ideas?
Absolutely. So, what a trademark is and does is it doesn't protect your idea per se. You invent something that has nothing to do with a trademark. It protects your name, your company name, your product name, your brand, your logo, whatever it is that identifies what you sell as yours. That's what a trademark is good for. Now, one of the hard parts about trademark law is you have the federal trademark registration, which is a US wide database. You file your trademark application, you get your registration, and you have all your trademark rights.
Mhm.
You also independently can have common law rights in each state. Each state has their own trademark laws. It's not registered, it's not a trademark that you can enforce everywhere in the country. You can only enforce those rights where you use them. Now, that's the downside.
Right.
The upside is if all you care about is your local market, it's rock solid protection. And it's a lot harder for potential infringers to find. So somebody else can maybe go down a certain pathway, start accruing damages, and then you can surprise them and say, hey, you need to pay me and you need to stop. So, in addition to federal registration and federal protection, it's also possible to get common law protection in each individual state. All of the 50 states have their own process, scheme, pathway for getting a trademark registration in that state. There's no nationwide registration for that. Those state law, common law trademark rights are only good in those states where you're using them. So if you happen to be, for example, in the DC area and you use your trademark, you never federally registered it, but you use it in Maryland, Virginia, DC, you have protection in those places. But if somebody wants to go to Pennsylvania and use your rights, they can. That's the downside.
Mhm.
The upside is it's a lot harder to find. So if big company wants to come and use your trademark nationwide, maybe they do a federal search, didn't see anything, so they think they're free and clear. They start using the trademark, they start selling, they start, making profits. You can then come in, say, hey, no, 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 we have rights here in DC and Virginia. You have to stop. And you owe us damages. I've been in situations where big companies have been faced with that after they've been on the market for a while and have been very upset that they didn't know about it before they started.
Right.
It means that they wasted a lot of time, a lot of money, and now they have some potential liability.
Interesting. Another aspect of intellectual property is copyrights. Here's a situation that I've seen occur in a number of cases, and I'd like to get your particular take on it. Somebody is starting up a software business and they don't have much money, so they get their former college roommate to come in as a volunteer and do some coding for them. And they do the coding, and it's just based on a handshake. Uh, the friend provides the coding, and it turns out to be one of the central features of the software program, the software platform. And since it was given as a gift, there's no problem with using that. Isn't that right?
Well, technically, you can use it. The problem is, so can other people. It was a gift. There's no contractual arrangement, there was no negotiation. Typically, if you're bringing somebody along to write that code for you, for example, you can put a contract in place with them, call it a work for hire. You own the rights because they're doing something for you. If you don't have that contract in place, if you haven't pre negotiated that, that person who wrote that code maybe sees that's central to what you're doing and you're successful. Maybe they want to do it themselves. Maybe they want to sell it to your competitor. You have no way to stop them.
Are you telling me that you really do need to have written agreements for something like that, Josh?
You sure do. Absolutely. You need written agreements for everything. Back in the 1900s, maybe you could do things with a handshake. Not anymore. There's too much money at stake and there's too much risk involved. Do I want to say 100% of the time it will fail? Nothing's 100%.
Right.
99%? Yeah. I would not bet anything on it.
Now, people tend to think of patenting and they say, well, I'll get a patent on it. But without realizing that patents are creatures of national law. So if you get a patent in the United States, you can stop competitors from competing in the United States. But if you have an invention that has worldwide implications, if you don't get patents elsewhere in other countries, then people can just copy what you do and use it freely there. How do innovators get around this conundrum, and what sorts of techniques are available to help protect them so that at least they have the freedom to patent something in other countries when they file in the United States?
Sure. So when you file in the United States, like so many other aspects of patent law, it starts a clock. It starts a 1 year clock. And what that means is from the day you first file your patent application in the US, you have 1 year to file internationally and protect your rights in whatever countries you want to protect them in. Otherwise, just like you said, Phil, all you need to do is go to Mexico, Canada, Europe, Japan, and you can practice, somebody else can practice whatever it is you patented.
Mhm.
Now, that does not necessarily mean you need to make all those decisions within that 1 year. because there's something called the Patent Cooperation Treaty, PCT, as those who do what I do call it. You can file that PCT application by that 1 year time frame. And it's like making a dinner reservation. You call up the restaurant, you say, hey, I want to have a seat for dinner for 4 Saturday at 6 p.m., and they'll hold it for you.
Right.
PCT operates the same way. Instead of having to file internationally at 12 months, you get an extra 18 or 19 months, so 30 or 31 months total, depending on the country, before you have to file in each of those countries of interest. Why does that matter? Why is that important? Well, it's a very expensive process to file in each of these countries because you have to pay lawyer fees in each country, you have to pay official fees in each country, you have to go through the examination process in each country. It's a multiplier. Whatever you're going to spend in the US, if you file in 10, 20, 30 more places, it's at least 10, 20, 30x, possibly more. If you have to add translations, higher fees if you're dealing with Europe, things like that. Anything you can do to delay making those expensive decisions until you know, one, where you're going to get the most value for your filing, two, do you have the money, and three, is this invention really something that I can sell? You don't want to have to do that before you know the answers to these questions. Do you always know at 30, 31 months? No. Is it a better chance that you will than after 12 months? Absolutely it is.
So it seems to be a matter of timing to try to give the innovator some extra time to determine where the most profitable areas to continue the patent protection. What
Exactly.
does
And
I
something
realize?
oh, sorry.
Go ahead, please.
Something that goes into it, nobody, and I mean nobody, can file in every country in the world. So you really have to look and think, where do I expect to make my profits? Where do I expect to have my sales? And where do I expect to manufacture? And that should always be your tier A, the top list of countries that you want to file in.
Mm-hmm.
And then after that, you can have nice to haves, things that are maybe, well, I can afford that, so why not? But you really, really want to protect those most important markets.
Can you give our listeners sort of a price range of what to expect in terms of putting together a US patent application and a PCT patent application, realizing that it's highly dependent on the nature of the technology involved? But I sometimes see on the internet these claims: sign up with us and we'll give you a patent application for $500. And I always, the statement always comes to my mind that you get what you pay for. And
Yes.
so for $500, you get $500 worth of IP protection. But can you give us, kind of an indication of kind of ballpark, and then the sorts of things that go into the cost of the patent application so that our listeners have an understanding of what to expect?
Sure. So when I get asked this question all the time, without knowing the technology involved, I always give an answer. You have to expect to spend at least $8,000 to $15,000 from when you start with me to when we have a patent application on file. That
Mhm.
includes a search. That includes drafting the patent application, both the claims, which are the part that gives you your protection, that is what you can stop others from doing, as well as the specification and background, all the details about how your invention works, what it is, what the alternatives are. And where some of that money goes, quite frankly, is in not only taking your initial idea and filing that, but brainstorming with you. What if we change this piece? What if we expand this out? What's the next stage?
Mhm.
Because when you're starting up, you want to have as much in there as you can to try to protect as much of the world as you can. I said a few minutes ago, one of the reasons why you get a bundle of patents is to not just protect what you're doing, but what somebody else could be doing similar.
Mm-hmm.
When we write that initial patent application, we want to be thinking about those things. How do we maximize that first shot? Give you, again, the best value for your money. And that's really part of it. And then, of course, depending on the type of invention, you have to have drawings showing every piece and part of the invention, labeling them, describing them.
Mm-hmm.
And they are very technical drawings. There is a fee involved with getting an expert draftsperson to draw out those drawings in a way acceptable to our patent office.
Mm-hmm.
And then finally, of course, you have the filing fee, the official government fee, because the government doesn't do anything for free, let's face it. They
Yes.
don't. And if someone is quoting you $500 for a patent application, I can almost guarantee that is not for a full utility patent application, because the official fee will eat up almost all of that if you're a micro entity, the smallest of the small, or it won't even be enough if you're bigger than that.
All right, that's super. Well, now we've come to the part that I hope people were waiting for, which is the one or two super tips that you have, Josh, to try to help people be aware of so that they can better drive their businesses.
Absolutely. So the number one tip, which I teased before, you come to me, you say, here's my idea. I do a patent search and I tell you, look, you don't have a patent here. I can file a patent application for you. The chances of success are really low. What I tell people they can do instead is develop your product, your service, whatever it is, develop a very, very strong brand for it, whether it's a name, logo, both. Get very strong trademark protection, get out on the market, make as much money as you can, as fast as you can. You want to be known as the leading provider of what it is that you sell, so that anybody who wants to buy what you're selling, they're going to come to you first. And anybody who wants to compete with you, they're going to have to compare themselves to you, right? They can't make a name for themselves. They have to say, well, I'm like your product, just cheaper, just different, just, I have these other features. But everybody knows if you want a tire, you buy a Goodyear.
Right.
That's the number one tip. The second tip I have, and this, you go into this a lot in your book, Phil, when you're getting started, have a plan, have a process. If you don't know where you're going, wherever you wind up is going to be fine. Doesn't matter. You have no plan, you have no direction, you have no end goal in sight. Maybe you file a patent application. Maybe it relates to your service, your product. Maybe it doesn't. But hey, you filed something. Great. Now I can tell investors I filed something. That's not good enough. They're going to want to know, not only are you thinking to protect yourself, are you thinking to protect yourself in the right way to where any investment someone might give you is not a risk, or it's at least less risky. Because when you're talking to investors, they're not thinking about how great your product is. They're thinking about, what's my risk? What is my chance of seeing my money back and making a return? If you can present them the plan, and this is the path I'm going to follow, that makes you less of a risk. It makes you more likely to get that investment.
Super, Joshua. Thank you so much for sharing that information. The time has really flown by, and I want to remind our listeners that our podcast is a video podcast. It's available on all the major podcast channels. Please look for our book, Avoid Startup Failure, on Amazon. View our podcast, come out to our website, crowleylawllc.com. Make use of the free materials we have out there, and please remember, we're here to help. Thank you.
Thank you very much.
You've been tuning into the From Lab to Patient, Garage to Market podcast with your host, Phil Crowley. You can find this show on all the major platforms, including YouTube, LinkedIn, Facebook, Apple Podcasts, Spotify, and on our website, crowleylawllc.com. If you found this information helpful, please subscribe, like, leave a positive review, and share with others.